to make a to accent the legal aspects of this. Although, for those of you who have engaged with me, my interests go beyond that. But we will start with this. And so, and in particular, there are many aspects about platforms, but particularly because I'm in dialogue with Marshall's paper, I'm really going to be focusing on issues around fake news, content moderation, and the like. Obviously, platforms raise far more issues. The other panels will discuss many of them, but in this sense, we'll talk about some of the constitutional constraints that happen that apply. And as a basic overview to my talk, this is primarily about First Amendment limitations under the U.S. Constitution and how things will be handled under U.S. law. And to put the disclaimer on the bottom, my discussion is framed almost entirely by U.S. law because that is what I'm most familiar with. I have some awareness of some other regimes, but this is primarily a U.S. law discussion. And first, I'm going to talk about the First Amendment constraints on the government's ability to prohibit or mandate conduct. Second, we're going to consider different approaches to not just direct regulation, but imposing intermediary liability. That is, third-party liability, not for doing something wrong yourself, but facilitating someone else doing something wrong. And in fact, we have two different approaches under two different areas of law. Under defamation, we have one approach. Under copyright, we have a different approach. And we'll talk about how that works out and the constraints that surround that. And then I'll close with a brief comment about a current case that's pending before the Supreme Court that's actually scheduled to be argued on February 21, which is the first Supreme Court discussion of intermediary liability, the major statute on it on the defamation side, and talk about what many of us see as a potential distinction between intermediary liability for distribution and intermediary liability for amplifying speech, not just simply distributing it or making it available. So, without further ado, so if you understand, to look at the basic constraints or the basic case law under U.S. law on the government's ability to mandate or prohibit conduct, that is to correct for fake news, the first principle is the government is not allowed to restrict speech that is objectionable. So just a few classic examples: racial epithets, depictions of animal cruelty, different things. There's a violent video game example, things that people find to be low-value speech. The government is not allowed to be the arbiter of what is allowed to be said and what's not allowed to be said under the U.S. First Amendment. And this applies also to false speech. So there are a number of Supreme Court cases. There's one called Alvarez where a person claimed to have been in the military and received some very noted decorations, and they were all lies. There was a statute called the False Valor Act, which penalized that. It was declared unconstitutional, saying just because someone says something is false, we don't actually justify penalizing that. False speech about public figures. This is the famous New York Times versus Sullivan case. There's other cases, Brown versus Hartledge, where someone misrepresents something during a political campaign. And they said that the government is not allowed to actually restrict it because it's false. The other side is the government is not allowed to require an intermediary to provide balanced speech, to carry other speech in response to something that's perceived to be objectionable or incorrect. There's a case from 1974 called Miami Herald versus Tornillo, which struck down a statute requiring a right of reply when a newspaper endorses one candidate. The opponents had a right of reply under the statute, and that wasn't constitutional. And there's a case that's heading probably almost certainly to the Supreme Court next year on social media viewpoint neutrality. Florida and Texas both passed statutes saying that requiring there be non-discrimination, that all sides be brought out. One court, the Florida statute was held unconstitutional because this kind of balancing is not required. The Texas law was held constitutional, and we have a conflict that's almost certainly going to get resolved by the Supreme Court. But early indications from the Supreme Court on what they call the shadow docket, or their emotions about what do you do while you're waiting for the appeal to happen. The state of Texas requested that there be a stay, or the opponents requested that there be a stay, that the decision not be enforced. until it's heard. And the Supreme Court basically signaled in granting the stay that that's likely to follow the decision, prior decisions of declaring this to be unconstitutional. And then we have a bunch of political speech cases, Buckley, Citizens United, that says the government is not allowed to correct political speech markets. So why is this the case? Well, there's a general sense that, and this is, I'm quoting directly from a Supreme Court decision here, that private abuse exists, but correction by the state is riskier. The cure would be worse than the disease. There's a long legacy of thought behind this. John Milton's Areopagitica critiqued the British practice of requiring prior licenses before you published books, and involved in essentially amounted to state control of printing. And the belief is, he wrote a very eloquent complaint about this. And then somewhat later, that was in the 17th century. In the 19th century, Max Weber notes that the reason we are more suspicious is the state has a monopoly of the legal use of force. And there is the threats of exercise by the government are perceived to be riskier than by individuals. And there's also a part of this that is part of liberal theory, which says that people are subjects that create the state, not objects subject to engineering by the state. And this goes to social contract theory, whether it's Locke and Hobbes, and I really think of this in terms of Isaiah Berlin, that really thinks about the proper relationship here is that, in fact, the concern is always really summed up by Rousseau, is when you assume that people are suffering under some form of false consciousness, you can get some arbiter who knows better who can, to use Rousseau's phrase, force them to be free. And in a liberal theory idea, that inverts the idea. You can't force people to be free. By definition, that's up to them. And this is really encapsulated in the law by a dissent by Justice Louis Brandeis in 1927, is that the remedy to apply to false speech is more speech, not enforced silence. That is, the remedy to bad speech is more speech. And so the idea is not to restrict it or to put mandates on it, but rather to allow people to correct the record by opposing it and disagreeing with it. There are a number of exceptions to the rationale. Children exist because the minors are too young to decide for themselves, and we have more leeway. That isn't a blank check. Most notably, there's a case called Brown versus Entertainment Merchants Association, which struck down a California requirement that violent video games not be sold to minors without parents' consent. And they said that the record just doesn't justify that kind of restriction, even for children. And there is a broadcast, we see a lot more regulation in the US on broadcasting. It was justified by a rationale called the scarcity doctrine, which is now considered discredited because everything's scarce, not just broadcast spectrum. If you see the Supreme Court's reaction to it, it has been asked to extend it to other forms of communication, internet, cable, telephone, a long litany, and none of them, the Supreme Court has refused to extend it to all those doctrines. And then, in fact, a cautionary note, the experience under this doctrine was that it was politically manipulated for partisan purposes. Most notably, there's a wonderful book that looks at how the fairness doctrine was used during the 1960s by the Kennedy and Johnson administration to systematically suppress Republican speech. And so there's another level to this, which is the worry is any rules, they all can be gamed, and almost certainly will be. So the assessment on this, Supreme Court decisions have adhered to a deontological approach to where really it's speaker-based, not really looking at effects-based. Exceptions don't really apply well to fake news, and that because fake news isn't about just about kids, and it isn't just about broadcasting. It's a more general problem. And there have been some calls from Justice Gorsuch, Justice Thomas, and noted scholars to change from this line, but there is not really any indication, and some pretty clear indications that that view remains in the minority and is unlikely to occur. All right. So talking about intermediary liability, there are two major regimes that govern this. One that governs defamation, one that governs copyright. Defamation is governed by a statute known as Section 230, which is a source of great publicity these days. And it sets up basically two forms of immunity, and it's kind of a misnomer because the word immunity is not actually used, but but effectively that's what it's easier to talk about it that way. One clause gives immunity if you simply distribute content and without editing it. So if you're a distributor, not a publisher, you actually are fine. And then there is a immunity for Good Samaritan actions taken on behalf of other people. That's for content that is obscene, filthy, excessively violent, harassing, and it's a list of terms. Even though you're exercising editorial discretion, you're allowed to take that kind of content down, this obscene, objectionable content, without losing immunity. And they considered and rejected whether you should set what we call a notice and takedown regime, which is a different approach, which is the one taken under copyright, is that liability, to maintain your immunity, you can post things, but if someone raises an objection, if you take it down right away upon notice that the speech is potentially illegal, you maintain your immunity. But if you don't necessarily do that. And in defamation, the courts rejected that it would lead people to take down too much speech. The concern would be is without actually considering whether the claim was valid, that the content was illegal, the intermediary would say, why run the risk? If there's even any claim, let's just take it down without even looking at it, evaluating the truth of the claim. And that is sort of the concern, that we'd see an overabundance of speech being taken down. In copyright, you actually have a different regime, which is you have, under common law, a third-party liability regime which holds intermediaries liable if they induce infringement or profit from infringement while declining and exercising a right to stop it. There's also statutory immunity, as I said, for notice and takedown. And that's exactly opposite to what we saw in defamation. The rationale behind this is that a degree of immunity will promote hosting more content, and more speech is good. There's a rationale that applies less, which is these young industries needed the help. Notice and takedown also raises the concern that it'll lead to blind takedown of speech. And we see a difference here between defamation and copyright. You see, defamatory speech needs breathing room to survive. So even if it's actually technically not true, it needs to, unless you intentionally repeated a falsity, it's not illegal. But copyright speech is implicit in this distinction, is that's less problematic. I mean, so you lose some YouTube videos, that's less important than defamatory speech. We actually had to experiment in whether these rationales were justified. Well, first, the DMCA has engendered so many complaints that notice and takedown causes people to take down. People who don't even have a copyright in the speech will lodge a notice and it'll get taken down. And so it's flat out fraud. But what we saw in a 2018 amendment to Section 230 called SESTA and FOSTA, Congress withdrew immunity for sex trafficking content, and that what you saw is a wide number of intermediaries would take down all the content that even remotely resembled this. The most notorious one is Craigslist used to have a very popular personal section. They took it down because there was some danger there would be solicitations for prostitution embedded in them. And so you lost not just the speech that they targeted, but an broad range of speech around it. So expanding intermediary liability, there is something, that experience suggests that there may be something to reducing the amount of content, and that defamation and copyright are different. My last slide, we do have this burgeoning case in Gonzalez versus Google set for argument on February 21st. The facts are pretty heinous. There's a family of a person who's killed in Paris is suing YouTube, and there's this parallel suit against Twitter for recommending videos that recruited people to join the Islamic State. And the lower courts in this case consistently recognize Section 230 immunity. What's shaping up as the fight is whether, even if Google were immune, if it simply hosted the content on YouTube, does its act of extending, of recommending that through its engines to offering targeted recommendations go beyond mere hosting and going into amplification. And under the lingo we'd have here, at that point they're no longer simply a distributor, they're now exercising some form of editorial control, not over the content, but actually of promoting it. In which case I think that that's potentially a problem that would lead to liability. All right. That is all my comments. I hope that is helpful and sets off an interesting discussion with Marshall and with Jeffrey.